Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And we're continuing our video series today on issues that are relevant to family law and relevant to the biases that are in the family courts. So please subscribe to our channel. Today we're going to talk about parental rights and are they truly equal? Well, I will tell you this. Historically, it can be argued that they were not equal. Historically, it can be argued that there was a bias in favor of the mom in terms of custody and those things. The court has really tried as best as it can to get away from that model and to judge the parents equally as it relates to what's in the best interest of the children. Now, it may turn out that the court may nonetheless find that it's in the best interest of the children to go with mom. She's more available. Maybe she's not working. Maybe the dad works $100 a week. Maybe that's the model that's going on, and therefore it's in the best interest of the children to stay with mom. But it won't be because the mom is mom and it's a gender analysis. It'll be because the court feels that the best interest of the children are promoted by being with this parent rather than that parent. And that could be the way it's going. So is there really a maternal bias at this time? I would say if there is, it's a shortcoming of the system, because every effort is being made right now to promote not the mom over dad or dad over mom, but to promote the best interest of the children. And therefore, in order to pursue that, what one should do is gather as much evidence as you can, gather evidence involving the child's life, be willing to negotiate with the other party to try and work this out. And if you are doing that, and if the court sees that, it'll help you. If you can't work it out anyway, you're willing to negotiate, you've gathered all your information, the other side is just drawing a line in the sand and not willing to negotiate with you, I gotta tell you, that's what the guy in the black robe is for. He's for a circumstance where you can't work it out. The judge is the one who is, authorized by the state to use her judgment to determine what's in the best interest of the child. So if you can work it out, great. If you've gathered your evidence and you've tried to negotiate in good faith, that's terrific. Be aware, though, that, sometimes people are just not ready to negotiate in good faith. Sometimes something has to happen before they actually come to the bargaining table and are ready to deal. And it could be that you have to be involved in the case for a long time, and you have to have a lot of evidence and a lot of accusations and a lot of refutations brought in, a lot of time spent. Sometimes it takes that effort to get people to the bargaining table. Sometimes it doesn't happen, and you can mediate once, twice. We've had cases we've mediated 4 or 5 times before the parties finally were able to settle it. And invariably, the case will settle at a place where we would have been at 9 months before. 9 months of aggravation, 9 months of legal fees, 9 months of going through it just to get the same thing as before. And why? Because the parties emotionally weren't ready to sit down at the table and make the deal. Maybe there was too much hurt. Maybe there was spite. Maybe there was the whole thing that you did this to me, so I'm going to turn the screws on you. Maybe that's what was going on. The emotions are involved. But once that is pulled out of the equation, you will find that in most cases, the drama no longer being a major part of it, the parties can settle nearly everything. So hopefully you'll get to that place. If you're having trouble maneuvering things so that you get to a place of negotiation and you need some guidance, reach out and we'll be glad to help you out.